What's up, YouTube? Hope everybody Friday's going good. Happy Friday, TGIF. Today I'm going to be doing a breakdown of the arraignment hearing for the mother and son that was involved in London Thomas's death. And I'm also going to show some court information as well. So just give me a second so I can get this pulled up and get it started for you. And before I even begin that, let me say my copyright disclaimer under Section 107 of the Copyright Act of 1976. Allowance is made for fair use for purposes such as criticism, commentary, news reporting, scholarship, and research. She looked like she worried. She should be. This will even look crazy. So for their attorneys, these are not public defenders, by the way. These are private counsel, retained counsel, meaning they paid. And I'm not sure if everyone is aware, but this family does have money. They have a trust. When I was doing my deep dive.
22nd District Court is now in session with the Honorable Judge Sabrina Johnson presiding.
Good morning, everyone. Please be seated.
They both look worried.
Case number 25-1709 and 25-1710 FY People versus Charlotte Pendergrass, People versus Jalen Pendergrass.
And good.
Dominic DeGrazia, P69815 on behalf of the people.
And good morning, Your Honor. For the record, Terry Johnson, P70773 on behalf of Ms. Charlotte Pendergrass, who is present and stands to my left.
Good morning.
May it please the court, Judge. My name is Adam Clements. My P number is 77233. I'm here on behalf of Mr. Pendergrass.
Yeah, like this is his first damn case. The one on the right.
Good morning, everyone. Okay, today is scheduled for arraignment. Do you wish to have the charges read? Mr. Johnson.
Your Honor, for purposes of arraignment, we'll waive formal reading on behalf of Ms. Pendergrass, and we'd like to enter a plea of, ask court to enter a plea of not guilty.
Very well. As to Ms. Pendergrass, court will now plead not guilty. As to Mr. Jalen Pendergrass.
Your Honor, we waive the formal reading of the information that's to allow the defendant to stand and have a plea of not guilty in on his behalf.
All right. Court will now plead not guilty on behalf of Mr. Pendergrass. As to bond for Ms. Charlotte Pendergrass.
Your Honor, while I understand that these charges are very serious, I'd like the court to take into consideration the mere fact that this matter.
So there go London Thomas's family in the back right there. They made it just in time as well. Look at her face though. These two are sketchy. Both her and her son is sketchy as hell. I'm gonna continue.
I'm sorry. Oh, Your Honor, I'm sorry, I'm normally used to a prosecutor being in the courtroom. My apologies, Mr. DeGrazia.
Judge, I ask that there be no bond set for each defendant, or alternatively, a very high cash bond. Regarding Ms. Charlotte Pendergrass, she does not have any criminal history. However, she is charged with second-degree murder. And I think more importantly, for bond purposes, this is a case where the evidence, I believe, will be abundant that both.
No emotion, no care in the world. You can see her facial expression. Like she feel like she over it.
Defendants, but particularly Ms. Charlotte Pendergrass, engaged in a extended campaign to lie to the police, lie to law enforcement to cover up her actions. She was originally charged with lying to a peace officer, which was later dismissed because an FBI agent is not a peace officer in Michigan. But the point is that Ms. Charlotte Pendergrass, I don't believe, can be trusted to follow the orders of the court. She has shown in the past her willingness to be deceptive, to be untrustworthy, and given the serious nature of these charges and the circumstances behind the actual crime itself, I'm asking that there be no bond for Ms. Charlotte Pendergrass, or alternatively, a very high cash bond.
Mr. Johnson, you wish to respond?
I do. Your Honor, I'm just rather shocked that the prosecutor can say that my client is not able to follow court orders. This court is aware Ms. Pendergrass was placed on a bond, a high bond, and Ms. Pendergrass followed all of those bond conditions. Not a single time was there any allegations that she violated or did anything that she should not have done. As a matter of fact, Your Honor, even after the case was dismissed, that was back in August, so about 3 months ago, she's done absolutely nothing. She has nothing to hide. The problem is she didn't cooperate with the police in a manner in which the police wanted her to cooperate. To come forth and say no cash bond, or to say no bond or a very high cash bond is ridiculous. She is not a flight risk. She's been here at every single court event. And
So they're pretty much arguing whether or not she should get bail. The prosecution made their argument saying that she shouldn't, or if she does, it should be a high cash bond, given the fact that this is a murder charge. Meanwhile, her defense attorney is arguing that she does not have a prior criminal history. She did abide by all the bond conditions that she had before previously, and she doesn't consider this to be a flight risk. But that's actually not true, because whether or not that has anything to do with it, they have access to a family trust, so they have means pretty much to be considered a flight risk. And the fact of the matter is that you're facing murder charges, so I don't think bond should even be a condition. It shouldn't have been a condition the first time around. So that was one of the mistakes that the courts had made. And before, the bond was like $50,000 for her, and the bond was $25,000 for her son at that time, when he was facing the other charge in Oakland County for lying to a peace officer, or lying to the U.S. Marshals about something. So they shouldn't have gotten a bond then, but they were posted bond at that time. And now we're trying to see whether or not they're going to get bond for this actual murder.
I would ask that if the court sets a bond, that it be a reasonable bond. Again, based upon her actions that this court has saw, not the allegations that have been put forth by the people.
Thank you very much. And
Would the court like me to address Mr. Jalen Pendergrass?
in just 1 second, I had just a couple of questions. Where does she work?
She's a caregiver, Your Honor.
She's someone who lives in the home?
No, Your Honor.
Yes, no, which one?
And the address we have for her on Roth, is that the best address?
On what street, Your Honor?
Roth.
No.
Okay, so if Mr. Johnson, if you can make sure we have an updated address for her.
I will take care of
That's
that.
not the correct address. The address that is correct, how long has she been there?
Approximately a year, Your Honor. Is this the address out county, outside of Inkster?
Whatever her current home address is, how long has she been associated with her current home address?
Oh, over a year.
Okay. All right, court, in consideration of the charges, in consideration of public safety, and I am concerned about the charges that include tampering of evidence and/or allegations of not being cooperative with the police. The court is going to set the bond at $5 million cash,
Damn.
and you're not to leave this.
So $5 million cash means pretty much they want all of it. Surety means like 10% of it. Cash means they want the full $5 million to get out.
State of Michigan without permission of the court. If you do make bond, you'll be on a GPS tether. You may not be in possession of any weapons, ammunition, drugs, or alcohol, and you can have a seat for the moment. Mr. DeGrassi asks to Mr. Jalen Pendergrass.
Well, obviously, Your Honor, the seriousness of the charges are severe. I would ask for no bond or very high cash bond, but Mr. Pendergrass specifically, he again, like his mother, showed a willingness to lie to police and to deceive police. But more than that, he is presently charged in Oakland County with making a false report of a felony. He was originally given a tether bond, which was reduced. And since that bond was reduced, it's my understanding that the defendant has recently been arrested under suspicion of operating while intoxicated. Now, it's my understanding he hasn't been charged with that crime, but he said at least has had police contact while he's been on bond in a pending case in Oakland County. So for those reasons, Your Honor, I again ask for no bond or a.
So he was out on bond in Oakland County for lying to the U.S. Marshals, but while on bond, he pretty much caught another charge where he was drinking. He was under the influence and operating the vehicle pretty much, and that is a violation of bond or of bail. So I don't even see why he wasn't even scooped up and scooped up then at that time when the incident took place. This just tells you, this is just proof that our criminal justice system is so broken. Like, look how long it took to even get to this point. They actually had an anonymous tip that was made back in April. So it's like, y'all had this information, y'all been sitting on this information for about 6-7 months now. And we're just now finding out about the witness who pretty much placed her body in the SUV. That was a friend of Charlotte's, the mother.
Very high cash bond.
Yes, that's what I would say on behalf of Mr. Pendergrass. It's interesting and rich that the prosecutor brings up my client's Oakland County case. A case which I believe undeniably will be dismissed. The reason why my client's bond was decreased in that particular matter is because the case is in fact so weak. But nonetheless, I'm in a venue where litigation is underway. We have a motion to dismiss that's pending in that regard, and I think that we'll be successful. But I think what's pointed in this particular case is that in that particular matter, my client was placed on house arrest tether. During that particular time, he never missed court, he never violated any conditions of his bond. But moreover, and more importantly, as it relates to this investigation, in this case, when did Mr. Pendergrass ever flee the jurisdiction? When did he ever run from law enforcement? When did he ever refuse to come in and meet with them? And it's news to me that he ever provided any false statements. I'm sure Mr. DeGrazia will give me some discovery to that effect, but I've never seen any of that information to suggest that he's provided any false information to law enforcement. So rather than attack a criminal history, the prosecution is asking the court to look at allegations that didn't even lead to a charge as it relates to an OWI. And that's purposeful. And the reason for that is because my client has no significant criminal history that the prosecution can point to. He's been compliant throughout this entire ordeal. So to somehow suggest that he would be a flight risk when he's never fled or done anything to that effect suggests that he's a flight risk simply because we decided to charge him after 6 months. So what I'm asking the court to do in this particular matter is to consider the fact that if the defendant is compliant all the way through, retains counsel, and does everything that he's asked to do, at what point do we actually respect the fact that he's presumed innocent? I'm asking the court to set bond in this particular matter at $100,000 cash surety. My client can go on house arrest tether. He's not employed.
100,000, sir. Get the hell out of here. That ain't nothing, because we know that he can post that bond. That's probably why he suggested that, because again, his family has a trust that they have access to, so they come for money. But 100,000, nah, that's a slap in the face. That's a slap in the face to the victim.
Right now, we don't have any objection to him being on house arrest, and he's already demonstrated that he can comply. But more compelling than anything, judges, he's looking forward to having an opportunity to finally have his name cleared. We want the evidence to be brought forth just like everyone else does, because as of right now, only the prosecution has that evidence. We've never seen anything that suggests that he's broken the law in relationship to the death of London Thomas, or that he's obstructed justice in any way at all. So for those reasons, Judge, I'm asking for a fair and reasonable. Thank you.
Okay, considering the factors that this court must consider in order to set bond or any type of pre-trial release, given the nature of the charges, was Mr. Pendergrass working at or around the time of the incident? And if so, where and how long?
Well, that's the time. At what period of time?
Back in April.
Well, he wasn't allowed to work, Judge, once he was charged in Oakland.
Okay. What was he doing before that? Where was he working?
He was not working.
Okay.
We've done it
All
cool.
right, and, so the court is going to remand Mr. Pendergrass, no bond, given the nature of the charges. And, we need to set a probable cause conference date. Is everyone available to zoom in for a probable cause conference on the 22nd of October,
What time will that be, Your Honor?
9 a.m.?
Yes,
I'm sorry, Judge, I didn't catch that date.
October 22nd, 9 a.m. for PCC on Zoom.
On behalf of Ms. Pendergrass, Your Honor, I'm available, or will make myself available.
I made work.
All right, Mr. Grassi, you're good with that?
That's fine, Judge.
All right, and, we'll set dates for next year. We'll set exam dates. I was gonna try and see if we could pick exam dates since I have all of you here and everybody's got a calendar.
Oh, I understand, Your Honor. I would hope, once we receive discovery,
Then you'll have a better idea of how we need to schedule.
yeah, hopefully I'll get it all this time.
All right, we'll see y'all first, on the 22nd, 9 a.m. Thank you.
Thank you, Your Honor. You said that very thing.
Ralph.
Let me go back because I didn't hear anything about the bail hearing for him. I mean, the bail amount set for him at all.
And, we,
Work, Judge, once he was charged in Oakland.
okay, what was he doing before that? Where was he working?
He was not working.
Okay. All right, and, so the court is going to remand Mr. Pendergrass, no bond, given the nature of the charges.
Okay. So he pretty much got no bond. He's pretty much been remanded, so he's going to stay in custody as well. The mother is too, unless you can post a $5 million bond. But I'm gonna stop sharing that and then switch over to the other piece of information. All right, so this is the case for Jalen Pendergrass, that's the ex-boyfriend, and Charlotte Pendergrass, that's the mother. You see right here, they're scheduled for another probable cause conference. Well, that was their arraignment, but they're scheduled for their first probable cause conference, October 22nd at 9 a.m. The same for his mother. Both are facing second-degree murder charges and also tampering with evidence as well. If convicted, they can both serve up to life. And following the probable cause conference, you're going to get a preliminary examination. That's usually done 7 days from that particular day. So they may be back in court the last week of October, the week of Halloween, I believe. I want to say, can't be for certain. Let me see. Yeah, bond has been denied, so he gets to stay locked up. So yeah, that's all I pretty much got for you guys. I'm hoping that they share more information about the probable cause conference next week. If not, I know for a fact they're probably going to share the preliminary examination whenever they get around to it. But I will be following this case as it goes to trial. I'll actually be in the courtrooms a few days that it does go to trial. I'm not sure when, but whenever the trial does happen, I will be there. And I'm also going to try and get transcripts from the preliminary examination as well, just to do a deep breakdown of everything. But that's all I got for you people. Don't forget to like, share, subscribe, comment if you're not. Have a good one.